Hi, good morning. My name is Romy Jurado. I'm an attorney, and today's class is going to talk about probate for realtors. This class is being recorded, so if everything comes out well, I'll be able to send everybody a follow-up email with the presentation. There is I don't see a Q&A feature here, but I do see a chat feature. So if you have any questions, you can put them in the chat, and then we can make this very interactive. I'm an attorney, like I mentioned, in the state of Florida. In my firm, we don't just do probate, we do real estate law, litigation, immigration, state planning, and trademarks. And you will see that probate deals with a couple of those issues as well. Okay, perfect. Everybody should be able to see my screen now. So first of all, what is probate? Well, probate is a court supervised process for establishing the validity of a will. If there is a will, we have to establish in the court that the will is valid. It also works to identify and gather assets of the deceased person. You have to identify, see if there's bank accounts, houses, properties, companies, safety places, whatever there is, the assets have to be gathered. And then also the debts of the decedent, if there's any credit card debts and they make a claim, if there's any other type of creditor, maybe Medicaid, Medicare, all of those people, or all of those companies, they'll make a claim in the state, and then probate is used to pay those debts. And also to wind up the decedent's financial affairs, there is a tax return that needs to be done, and all of that goes through the probate process. And then lastly, to distribute the decedent's assets to his or her beneficiaries. What are probate assets? So probate administration applies only to probate assets. Probate assets are those assets owned in the decedent's sole name at death or owned by the decedent and one more co-owners that lack a provision for automatic succession of ownership at death. Examples of assets or property that may be probatable assets may include a bank account or investment account in the sole name of the decedent is a probate asset. A bank account or investment account owned by the decedent and payable upon death or transferable upon death to another or held jointly with rights of survivorship with another, it's not a probate asset. A life insurance policy, annuity contract, or individual retirement account payable to the decedent state is a probate asset. A life insurance policy, annuity contract, or individual retirement account payable to a beneficiary may not be a probate asset. Real estate title in the sole name of the decedent or decedent's name and another person as tenants in common is a probate asset unless it's homestead property. Real estate title in the name of the decedent and one or more or other persons as joint tenants with rights of survivorship, it's not a probate asset. Also, property owned by spouses as tenants by the entirety, it's not a probate asset upon the death of one spouse. And then we also have ladybird deeds, which we will talk about. One thing that I see very often because we also practice business law in the sale of businesses, is people think that if one of the owners died and they own the company, then the other owners of the company automatically have the right to dispose or sell of the company. That is not the case all the time. If you have an LLC or if you have a corporation and one of the owners dies, that interest, membership interest or ownership in the corporation becomes a probate asset, and it needs to go through the probate process for the other people to be able to inherit it, sell it, or do whatever with it. Unless the operating agreement or shareholder agreement has language that makes it automatically pass to another person upon their death. And it has to be very specific language, clearly written. The law is always changing, so it's always good to check that it's currently valid. But there is a way to add some language in an operating agreement or in a stockholder agreement where you make the interest or the stock ownership automatically pass through upon the person's death. But if that's not in the agreement, then that ownership in that company, it's a probate asset, which will need to go to probate in order for the other owners of the company to be able to sell or continue to inherit, or the heirs to inherit that ownership interest. That's something that I see a lot in the sale of businesses. We also see it in the sale of properties, and it comes as a surprise to people who think that if you own it through a company, then it shouldn't have to go to probate, but it does unless your corporate documents say that it passes upon that person's death automatically to whoever they decide it passes through. So that's important to keep in mind. What are and what is not a probate asset? So when is probate necessary? Probate may be necessary to transfer ownership of the decedent's probate assets to the decedent's beneficiaries. If the decedent left a valid will, The court will admit the will according to the procedures and to probate to transfer ownership of probate assets to the named beneficiaries. If the decedent had no will, probate might be necessary to pass ownership of the decedent's probate assets to those receiving them under Florida law. If you don't have a state plan of who inherits your assets, Florida law has a state plan for you. So it's something that it's already established, and I'll show you how that works in a minute. But that is why it's important if you wish to leave your assets to a specific person, you wish to disinherit, I don't know, your sister, your brother, your children, there is a way to do so, but you have to have a will in order to do so. Some assets do not require a probate proceeding to transfer ownership, such as the one that pass up immediately upon death, or the ones that have joint ownership with rights of survivorship. Probate may also be necessary to wind up the decedent's financial affairs, and administration of the decedent's estate ensures that the decedent creditors are paid if certain procedures are correctly followed. So yes, probate also works to pay creditors, because you have assets, they want to get paid from that, and it works for that as well. So what is probate in real estate? So whether it's an heir, seller, or buyer, the definition of probate real estate never really changes. Someone owned real estate, that person passed away, and in order for the rightful heir to have title to the real estate in order to sell, convey, or transfer, the heirs have to go through this formal court process called probate to officially transfer title. So if you have a listing agreement and you see that the owner has passed away, probate is going to be necessary in order for the other heirs to sell it. Even if they show you a will that says they're going to inherit it, that's not enough. That will needs to be probated, and the court is to say, yes, this will is valid, and these heirs have the right to sell the property, and it has to go through the probate process. And it can be a fast one, especially if it's homestead and nobody's fighting the validity. Probate can be really fast, and the property can be sold. The fastest we've done, we started the probate and we were able to sell the property within a month. So if you have a listing agreement and you identify that one of the sellers has passed away, it's the best thing to do is to consult a probate attorney to see how quickly you can start the probate so that when you have a buyer, you're able to sell it right away and you don't have to wait for this long drawn out proceeding. Why should realtors care? One, to avoid wasting time. You don't want to be spending all your resources. You list the property and now you realize that the people are fighting, the heirs are fighting as to whether to sell the property or not, and you already wasted all your time. So it's very important for you to understand when there's a probate issue, to consult an attorney, to get the process going, to make sure you're going to be able to sell. Also, you might be dealing with the wrong person. Maybe the sister told you, yeah, this is my brother, he has no heirs, and I want to sell the property. But then you find out that brother actually has children. So they are the ones that need to be in agreement to sell the property. So it's important to look into that too. Unless you're dealing with an individual who was appointed personal representative by the court, you need to ensure that the rightful heirs are on board with the sale in order to avoid delays. Also, to make sure that the state in the contract that the sale is subject to court approval. So it has to state, if you're doing a contract that is subject to probate, that contract should say that it's subject to court approval once you have identified the correct seller, especially if the property is not homestead property, since you will need an order authorizing the sale. So for all those reasons, it's so important to identify if probate might be something you need to deal with, consult with an attorney, and get the process going. So we have something called probate states. With a will, it's called testate. Without a will, it's called intestate. Testate succession. When the decedent has a valid will, then the role of the probate court is to distribute property according to the decedent's instruction in the will, meaning to appoint a personal representative as indicated in the will, unless it's summary administration, which is a faster one that doesn't require a personal representative. So anybody that's dealing with a probate issue, whether it's an heir or a realtor, they should figure out first if there is a valid will, and where it is. The custodian of the will is supposed to present it within 10 days of the person passing away. The will can also nominate guardians for minor children, and the will can be used to disinherit specific individuals. When there is no will, then it's called intestate succession. And then what happens is that Florida has a rule of who inherits and how. For example, we have this little chart here that we ask some questions. Did the person that died, did they have children? Did they have a spouse? Did they have siblings? And then we go down the list to see who will inherit and how, depending on what Florida law says. But this only applies when there is no will. If there is a will, then the person that's leaving the assets can decide whose assets, who's going to get the assets. The only thing that person cannot do is disinherit their spouse or their minor children if the property is homestead. If there is, however, a prenuptial or postnuptial agreement and the deed is only held on the person's name, then there might be a way to disinherit the spouse from the homestead property, maybe, if it's all done correctly. So types of probate, we have really two types of probate. We have summary administration and formal administration. Summary administration is more of a simple form of administration that does not require the appointment of a personal representative. It can be completed when the decedent has been dead for more than 2 years and the will does not direct formal administration. It can also be completed when the value of the entire state subject to administration in Florida, less the value of property except for the claims of creditors, does not exceed $75,000. So homestead property is actually exempt from creditors. That's great because you could have a homestead property worth a lot of money and your creditors can be wanting to come after it and they will not be able to touch it from your probate because it's exempted from creditors. So you're able to do the summary administration if your homestead property, whatever it's worth, it's fine. But then if your other assets do not exceed 75,000, then you'll be able to do the summary administration. We also have formal administration. Formal administration is usually needed when the assets of the decedent are in excess of 75,000, when the decedent has been dead for less than 2 years, when you want to get a personal representative appointed by the judge. And why would you want a personal representative appointed by the judge? Well, let's say that you seek to sell real estate during the probate process. You don't want to wait until it's over. You want to be able to get the order now and sell it. Then you want to be able to get that order. You will need formal administration. Formal administration is also recommended when you have multiple creditors, when you need to provide formal notice, and when the borrower is deceased and the bank does not want to provide informal information regarding the loan or the mortgage. Sometimes banks don't want to provide that information unless there's a personal representative appointed, and that's the reason why you might need formal administration. So in Florida, we have certain requirements to have a valid will. Sometimes we get people that are foreigners and they have U.S. property and they want to use their will from abroad in order to say who's going to get their U.S. property. But sadly, their will from abroad does not comply with Florida's requirements for a will to be valid, so we are not able to use it. Even wills from other states may not comply with Florida's requirements, and we're not able to use it in the state of Florida. Only a judge in Florida can decide and can do a probate for a property located in Florida. It doesn't matter where you died. It doesn't matter where you resided. If your property is in Florida, even if you're a foreigner, you're going to have to open a probate in Florida in order to be able to sell that property. And for that, we want to make sure that the will, if you have one, if the decedent have one, is valid. So in Florida, for a will to be valid, it must be in writing. It must be signed by the decedent and witnesses, and to comply with the execution requirements set by Florida law. In a will, the decedent can name the beneficiaries who the decedent wants to receive the decedent's probate assets. The decedent can also designate a personal representative, Florida's term for an executor, to administer the probate estate. So we have a specific statute that tells us what is a valid will. Florida Statute 732.501 provides that any person who is of sound mind, so it cannot be somebody that's, not of sound mind, and either 18 or more of age or an emancipated minor may make a will. It must be signed by the testator at the end of the document. If the testator is unable to sign the document, some other person may subscribe the testator's name at the end of the document in the testator's presence and by the testator's direction. It must be witnessed by at least 2 attesting witnesses, who also must sign the will in the presence of the testator and in the presence of each other. So basically, that's what we need. In order for the will to be valid, the person has to be 18 or an emancipated minor. The testator has to be of sound mind. They have to sign it at the end of the document, not on the side, not in the front. It has to be at the end. If they cannot sign, they can appoint another person to sign, a third direction, witnessed by the testator, and it must be signed by 2 attesting witnesses who must also sign in the presence of the testator and in the presence of each other. Yes, you can do remote wills, but I'm not comfortable doing them yet, so I like everybody to sign just because we don't want fights. Then we deal with homestead property. So if the owner of a property has a home in Florida that is his or her primary residence, Florida homestead law must be considered. So there is certain protections in the Constitution in the state of Florida that provides that the decedent homestead may not be devised, meaning you might not give it away, if the decedent has a spouse or minor children. There are some exceptions, right? So it may be devised to the spouse if there are no minor children. A surviving spouse can waive homestead rights in writing with a valid prenuptial agreement, and the prenuptial agreement must be clear and explicit. So if you wish to disinherit your spouse from your homestead property, it has to be via a prenuptial agreement that must be clear and explicit. Otherwise, they're going to be able to fight it, and they may be able to get it upon your death. So Florida law also provides that if not devised as authorized by Florida law in the Constitution, the surviving spouse shall take a life estate in the homestead property with a vested remainder to the decedents of the decedent's per stirpes, and the surviving spouse may elect to take half of the homestead as a tenant in common with the remainder undivided on half interest in the homestead vesting in the decedent's per stirpes. Meaning the spouse can choose to get a life estate, meaning she resides there during her life, and then it goes to the children, or she can decide to stay there and get half of the property, and the rest goes to the other decedent's heirs per stirpes. That's an election that the spouse can make. We also have something called a pretermitted spouse. When a person makes a will and marries after making of the will, the surviving spouse generally gets what she would have gotten if the decedent died intestate. Unless there is a prenuptial or postnuptial agreement addressing the issue, the will provides for the spouse, or the will clearly discloses that it does not intend to make a provision for the spouse. Important, the surviving spouse could request an elective share. So it's important to always update your estate planning documents. If you did your documents prior to marriage, you may want to revise them to make sure that your intentions are going to be respected upon your death. So what if a person dies without a will or legal heirs? Well, pursuant to 732.107 Florida statutes, the property reverts back to the state of Florida as a last resort. The property is sold and the proceeds are paid to the chief financial officer of the state. The escheated funds are retained as part of the state school fund, and after 10 years, the state rights to the proceeds become absolute. So if you are somebody that doesn't have a will and do not have legal heirs, but you wish to leave it to charity, you wish to leave it to your friends, you definitely want to plan that, because otherwise it will go back to the state of Florida, or it will go to the state school fund, and whatever your intentions were will not be respected. I remember I had a client who had no heirs, and what she wanted was that all of her money, which was over $500,000, went to the University of UM to set up scholarship for underprivileged children. And that is exactly what we did, and Will said that. And I remember that upon her passing, a bunch of people came about that said she was my aunt, she promised me the money, this and that. But because she had a clear will that stated her intentions, all of her intentions were respected, and the money went to the University of Miami to establish that scholarship. Otherwise, it would have been litigation, all these people would have complained, and God knows what would have happened. I mentioned before a personal representative. This is the person in charge of basically maintaining the state. And this is the person appointed by the court to oversee the administration or probate of the decedent state, who must comply with the following. They also get compensated from the state's fund. So they will notify all the heirs and other interested parties that the will is being submitted to probate. They will identify and take control of any state assets. They should file tax return and pay any taxes. They would be paying creditors, managing any assets such as investment or real estate while the will is being administered. They will sell to satisfy claims against the state. They will file all necessary documents and other paperwork with the court. They should distribute the assets to the heirs and prepare and submit any final accounting to the court. That is, what the personal representative does, and they're usually compensated for this per statute. Appointment of the personal representative. So we have a certain statute that says the following is the preferred order in appointing a personal representative, unless you have something different in your will. In intestate states, the personal representative or his or her successor nominated by the will. That's the first person. Then is the person selected by the majority in interest of the beneficiaries. And lastly, it's one of the beneficiaries. If there are many, the court selects the more qualified. In intestate states, meaning when there is no will appointing a personal representative, then it's usually the surviving spouse. Then we have the person selected by a majority in interest of the heirs. And then the heir nearest in degree, if there are many, the court selects the more qualified. I remember one time we had litigation over who the personal representative could be. So if you have people that you prefer to be personal representative, it is very important that you put it in your will. There's some people that can qualify. There's some people that cannot qualify to be a personal representative. Under Florida Statute 733.302, any person who is sub sui juris and is a resident of Florida at the time of the death of the person whose state is to be administered, it's qualified to act as a personal representative in Florida. Under Florida Statute 733.303, a person who has not been or is not convicted of a felony, convicted of abuse, neglect, or exploitation of an elderly person or disabled adult in any jurisdiction, mentally or physically unable to perform the duties of a personal representative, or is under the age of 18. So if you have any of that, or if the people you want to put as personal representative has any of that, they will not be eligible to serve as personal representative. One question that we get a lot is, can the personal representative be a non-Florida resident, especially when dealing with foreigners? So under 733.304 Florida statutes, a non-resident of the state of Florida may qualify as a personal representative if the person is a legally adopted child or adopted parent of the decedent, related by lineal consanguinity to the decedent, a spouse or a brother, sister, uncle, aunt, nephew, or niece of the decedent, or someone related by lineal consanguinity to any such person, and the spouse of such person of such a person otherwise qualify under this section. So if any of this apply, yes, the personal representative can be somebody that is not a resident of the state of Florida. How to avoid probate is something that a lot of people want to deal with, or think about, because they may not want to go through this court drawn out process. So generally, probate will not be necessary in the following scenarios. If you have property owned by tenancy by the entirety, meaning husband and wife purchase real estate as a married couple and one spouse survives, then all the other spouse has to do is register the death certificate in the court registry, and they should be able to stay with the property without having to go through probate. This tenancy by the entirety can work even for membership interest in the LLC, for having stock in a corporation if it's owned by tenancy by the entirety. It can work for real estate property, and it doesn't have to be just your homestead. It can be any real estate property that you own. It can be investment property. If it's owned by tenancy by the entirety, meaning husband and wife purchase it and title says that, then all the other spouse has to do upon the death of one spouse is register the death certificate, and they should be able to stay with the property. We also have joint tenants with rights of survivorship. If title to the property says it's owned jointly with rights of survivorship, then all the other person has to do is register a death certificate in the court registry, and they should be able to stay with the property without having to go through a probate. We also have property owned by life state deed. That means upon the death of the life tenant, the remainderment becomes the owner. This one too, it does not have to go to probate. All the person has to do is register a death certificate in the court records, and they should be able to stay with the property. Trust. If we have a property that's owned by a trust, then the trustee can sell the property, can dispose of the property, can maintain the property. This property does not go to probate because it's owned by a trust. And then we also have property that's owned by designated beneficiaries. For example, if you have a bank account where you set up to be payable upon death to somebody else, then that bank account will not go through probate. If you have a life insurance policy, an annuity contract, or retirement account, such as a 401k, and you have designated who will receive this property, then that property will not go through probate. So these are some ways to basically avoid probate. Lastly, here's some information on us. I don't see any questions yet. Let me see. No, I don't. But again, if there's any questions that we can help you address, whether you're about to list a probate property or have questions whether the property is subject to probate or who the beneficiaries are, or if you already started the sale process and you feel like the probate is taking too long and you just want to get a second opinion, you could always reach out to us. We'll be more than happy to assist you and help you in any which way to make sure you accomplish the sale and everybody's happy. Our office is in Miami, but we do help all over the state of Florida when it comes to probate. When it comes to immigration, it's all over the United States, trademarks all over the United States, litigation and estate planning all over the state of Florida. Our attorneys are fully bilingual, so feel free to reach out with any questions. Thank you so much for joining me today. I like to make these classes fast and to the point. My contact information should be there in the chat, so feel free to reach out with any questions. Thank you so much. Take care. Bye-bye.